I'm Mr. Schneider.
Where'd you grow up?
I was a geographic orphan, Stanley.
Okay.
Moved all over, grew up all over. Some say I never grew up, but born in the East, lived in Philadelphia, Phoenix, San Francisco, Chicago, New York City, the suburbs of all those. So I was a geographic orphan.
Where'd you go to college?
Undergraduate at the University of Connecticut.
And how'd you get to Texas?
When I was a junior in college, one of my professors introduced me to a lawyer in New York City.
Who was that?
A man by the name of J. David Tobin.
Okay.
And Mr. Tobin was from Texas, had gone to SMU School of Law, and basically gave me a book that was entitled Power Shift. It was a book about the shift of economic and political power from the Northeast to what the book described as the Southern Rim. So, read the book and decided to apply to SMU, got accepted and went there.
So you went to SMU Law School in what year?
74 to 77.
And then after that, SMU Law School,
After law school, Mr. Emmett Colvin, former president, who I worked for going through law school, assisted me in obtaining my first job, which was working for Truman Roberts, Court of Criminal Appeals of Texas.
so you worked for the Court of Criminal Appeals in 1978.
77 to 78.
And what was that like?
Well, it was a 5-judge court with commissioners at that time.
You had Truman Roberts,
Correct.
Leon Douglas,
Correct.
John Onion,
Correct. Odom.
Wendell Odom, and the fifth one.
Dowie, Green. Fathers came out of court at that time. Douglas.
Douglas,
You got Douglas. Leon.
Douglas, Onion,
Right.
Odom,
Roberts. I'm drawing blanks.
Me too.
I guess it's a senior moment.
What was it like working for those guys?
Truman was totally a delegator. The first day I started there, he took me into my little office and he said, "There's 130 shucks stacked here. Take
Shuck?
Shuck is the appellate record that has arrived at the Court of Criminal Appeals.
In a manila envelope?
Yeah, it's a binder manila envelope, sometimes this thick, sometimes this thick, sometimes it'd be 8 or 9 shucks per case. But there are 132 cases with associated shucks there. So take the oldest first, write me proposed opinion, I don't care what the result is, just follow the law. Just follow the law, total discretion.
And you went to work?
Went to work and worked from about 7 o'clock in the morning to about 7 o'clock at night for him, 6 days a week for about 11 months.
Were you married at the time?
No, I was single, but Truman actually married me in the Court of Criminal Appeals before I left.
It's all his fault, man.
Well, that was my first wife in a different life, but no, Truman did that because Emmett was my best man, and Emmett and Truman were very close friends, as was Truman and Frank Lloyd.
And who were some of the people that worked with you in the Court of Criminal Appeals, other lawyers?
Max Seacrest, who is, a very fine attorney in Houston, one of my closest friends in the world. Leslie Benitez, who was basically Texas's assistant attorney general that opened up the floodgates for the death penalty. Very
yes,
fine.
and she authored several opinions on cases of mine.
Yes.
Bernard McManus was one she worked on.
Really?
Yeah.
Well, Leslie's a very intelligent young lady, very sweet, but she bent the wrong way after working for a commissioner for a year.
Yeah.
Bill White was there. He was working for Horsepower Green, a commissioner.
Right.
Bill, is in the offices with me today. Those are the 3 primary briefing attorneys that I've stayed close with through the years. Most of the others went into civil law. And then, of course, we had Gucci Girl.
Who's that?
Kim Lambrose, who actually was an eyewitness to the shooting of a certain federal judge in San Antonio.
Oh, all right.
Yes, underwent hypnotic enhancement under Dr. Richard Garber to recall that she saw Harrelson.
Okay.
Yeah, so it was an interesting blend. Good year.
And so you went from Truman Roberts to Emmett Colvin.
Well, I started with Emmett in law school.
Right.
My second semester of law school.
As a lawyer.
Yes.
Tell me about Emmett Colvin.
Emmett was a sweet man. He really was a joy to be with. He was a real people person.
Right.
Very good on the law, had a reputation as an appellate attorney, but we tried so many cases together. We actually did more trials and appeals. Emmett had an ability to humanize a client to a jury, not with the type of flowery, robust language that a Ramsey or a Haynes or a Warren Burnett had, but in a much more common level that seemed to relate to juries. He once sang to a jury in a case during final argument. It's one of the first federal cases we tried together. Former Assistant Attorney General John Brady and his girlfriend, Glenda Morgan, had been indicted, 18 counts each of mail fraud, associated with one of John's former clients, who he had helped establish an insurance agency with. Unfortunately, the former client, who owed money to John and Glenda, was taking the insurance premiums, and as opposed to buying the policies, he was paying our clients. The bottom line is that John had been going around town telling everybody that this was his insurance agency. He was indicted by Ron Eddins, Assistant U.S. Attorney at the time. We tried the case 34 days after indictment. Discovery involved about 20,000 documents. And during the final argument, after I did the opening part summarizing the facts, Emmett got up to put his touches. And at the time, there was a phrase on television, Fort Worth National Bank, that's my bank, I can't sing. But Emmett sang that phrase to the jury in order to get them to relate to what John's, quote, admissions, that this was his insurance agency, really meant. You didn't own the bank. You might bank at the bank, so it's your bank. That's what John had done. He'd invested in this agency, but not as an owner, just by setting up his former client. And unbeknownst to him, the client was pilfering the insurance premiums, not to buy the policies, but to pay off property that John jointly owned with him. Unbeknownst to John. 36, not 50s. This is a lovely, lovely, lovely trial.
Have you ever heard anyone sing the courtroom before?
I had never heard it before, and I certainly have not heard it since. Other than occasionally when I get the one-word verdict, and I might sing a little bit, but it was very foul singing.
So tell me more about Emmett.
Emmett was a former president of TCDLA.
Right. No, not about that. Tell me about Emmett the man.
Emmett was a perfectionist. He went through different phases. He had his tie flying phase, where he would tie flies for fishing in the office. And while he'd be tying flies, we'd be talking about our cases. But he was a perfectionist. He concentrated on two things at once. He was an excellent photographer. TCDLA has some of his photographs of the Alamo. Emmett, like most criminal defense attorneys in that age, played hard, worked hard, drank hard. He married his first wife for the 4th time in a bar in Lake City, Colorado, after we won a case.
He married his first wife for the 4th time?
His first wife was his 4th marriage. I may have misspoken. So he went around the horn, so to speak.
All right.
But Emmett was a delightful man. He and the old-time Dallas lawyers who I was privy to meet would get down to the Sapango 21 Club and drink themselves and talk about their cases. And,
like who?
well, everybody from John Osorio, former Sharpstown defendant, to Jimmy Martin, Cecil Emerson, Charlie Tesmer. Charlie and Emmett practiced together. Now, they weren't together when I started working with Emmett in January of 1995, but I certainly got to know Charlie very well through Emmett. Masterful attorney, as was Emmett. Very good on the law, and were very progressive in their thoughts and their attitudes, having both come out of the Dallas District Attorney's Office under Henry Wade. They rebelled against that type of anarchy and conservative thought, for lack of a better.
So you worked for Emmett Collin.
2.5 years during law school, year at the Court of Criminal Appeals, went back to work with Emmett, cut my honeymoon short at his request, and worked with him from 1978 until when he left the practice of law to take the deanship of the National Criminal Defense College, which was then in Houston, which would have been 1981.
He replaced John Ackerman.
That's correct. That is correct. As much as Emmett is a fine attorney, he was not nearly as good of a dean as John was.
So in 1981, where did you go?
Well, Frank Maloney and Emmett and I had tried a RICO case in Dallas in 1980. And Frank told me after that case was over that if I ever wanted to come back to Austin, I'd always have a job. He wasn't going to try to steal me from Emmett, but he was very, very gracious to me. And so when Emmett decided to take the deanship, I decided to talk to Frank.
And
he made me an offer I couldn't refuse.
And so you moved to Austin to work for Frank Maloney.
1981, yes.
So tell me about Frank Maloney.
Frank? Oh, Frank is Dr. Klink. I love him to death. He also took me under his wing almost as a second father, as Emmett had done. Treated me very, very well. As a person, he was first rate. He is first rate. As an attorney, there's probably nobody I've ever worked with that works harder. And Frank, of course, only has one eye. One good eye, and that is not 100%. But he was a devotee of the law, very, very concerned about the quality of justice in Travis County. Very fair to me. A wonderful trial attorney, though most people did not think of him as a trial attorney. He had a unique ability to take complex cases, find the weak link in the armor, put the lever in and pry it open, and quite candidly, I like to think I learned some of that from Frank. I worked with him for about 5 or 6 years.
No one ever.
I went out on my own. I needed to establish an identity.
So, 1988?
88, yeah, about 88 I went out, and basically been on my own that entire time, with the exception of a small stint with some big Houston firm that went belly up, which you were over.
So, you're now, I guess, because of Frank and because of Emmett, as those were two founders of TCDLA, you were drawn into TCDLA as a baby lawyer.
When I left the Court of Criminal Appeals, I joined TCDLA. Emmett was just leaving his year. Vince Pariti was the incoming president. V had taught me Texas criminal trial practice at SMU School of Law.
Right.
And he appointed me to the amicus committee of TCDLA that first year. It was just being formed. And that's why I was drawn to TCDLA, certainly.
What does TCDLA mean to you? As a baby lawyer, following the footsteps of Emmett Coleman and Frank Maloney, two of the stalwarts of the organization, there's baby lawyer coming into this organization. Do you remember what it felt like to join this organization?
I was terrified, Stanley. Just like I was the first time I met Emmett, the first time I met Frank, the first time I met Percy Foreman.
Ooh, when did you meet Percy?
Percy when I was a law clerk working for Emmett. He came into the library where I was sitting and working on stuff. And Emmett was with me. Said,
describe him.
A huge man, a huge physical specimen man, much bigger than Emmett. Emmett was slight of build compared to Percy. Big shock of hair up there. And Emmett introduced him to
Describe his voice.
Oh, it was deep. It was a deep voice. It was 1975. It goes way back. But I offered, after Mr. Coleman introduced me to him, I said, Mr. Foreman, if there's anything I can do for you, just let me know. And he looked down at me and said, young man, I think I know and can find my way around the law library. Thank you very much. He was just jacking with me. But that was the only occasion in my life that I had the opportunity to meet Mr. Foreman. But it certainly retained an impression.
I remember the first time I met Percy.
Well, tell me about that.
I was we had co-defendants. And he was sitting in a hotel restaurant having breakfast as we were, and I went up and introduced myself to him on our way to court.
Well, I'm sorry I never got to try a case with you.
It was unbelievable. So you're with these stalwarts of criminal law. Did you ever work with Racehorse?
Yes. Yes, 1988, 89, 90 on a major SNL case in Austin. Richard was just a joy to work with. He and I actually got Richard involved with a client. I've been lead counsel for him, and I thought that perhaps Mr. Haynes could intimidate the government into not indicting the client. I managed once or twice to keep that from happening, but it appeared the handwriting was on the wall. So I called Richard, and we spoke, and he came up. The client gave him a bunch of money, which made him exceptionally happy, of course. And about 3 months later, one of the co-defendants asked Mr. Haynes and I if, in fact, I could shift from our joint client over to him because he didn't have confidence in his counsel. Richard and I spoke, talked to the client. Richard said, sounds good, we're going to have a joint defense agreement, no difference whatsoever. Unfortunately, I ended up getting disqualified from that case. And at the end of the hearing, which Richard was at, he said, well, David, I think you just got your client an acquittal on appeal by virtue of the disqualification. That didn't ultimately happen, but no, he was a dream to work with. Very, very fine attorneys. We all know a command of the English language that he, Warren Burnett, Mike Ramsey have a command of the English language that I could only...
You're mentioning some people.
You know who they are, and
Well,
you've worked with them all.
Tell me about Warren Burnett.
Warren was a fine attorney from Odessa. He had a command of the English language that was second to none, probably even better than Richard's. Warren was also a very hard-drinking attorney, sometimes during lunch, during a trial, and yet even when he had 2 or 3 glasses of wine at lunch during a trial, he is far better in the courtroom than I could ever hope to be. I remember one night Bill Wishcamper and I spoke with him on the phone at about midnight from Wishcamper's hot tub in Lubbock, and the phrases and the language that came out of Warren were just incredible. Fine man.
I remember Warren Burnett's voice was this booming voice, deep orator, and he just commanded the center of attention by his voice.
Undoubtedly, no question about that. And he commanded the respect of judges, and Warren could get away with things with judges that you or I never could do. In fact, I once saw him tell a story that was probably less than true, and yet the judge bought into it.
What was this story?
No, I don't want to go there. I'm going to take the fifth on that.
Oh, come on.
No.
Warren's dead, and probably the judge is dead.
Well, I'd rather not go there, Clark.
Oh, come on.
No. Some things need to remain unsaid.
The stories of our teachers. Come on, tell me the story.
No. This one isn't. I can't do it. I just can't.
No.
I'm sorry.
All right, I'll have to get it from you later.
Yeah, I'll take the fifth on it.
All right. So you've worked with Ramsey, and who's Mike Ramsey?
Actually, I haven't. I've only interfaced with Mike Ramsey. I've never tried a case with him. Mike Ramsey was one of the preeminent attorneys in Houston prior to his recent health problems during the middle of the Enron case. At which time Max Seacrest took over for Mike, and Max an excellent lawyer too.
David, you are known as an appellate lawyer, as a trial lawyer, as a workaholic, as a dedicated lawyer. What's your approach to a trial?
Well, my approach was to never let the client get indicted in the first instance. I believe that, like a football, I've got to be in better condition. I've got to be lucky. When the other side turns it over, there's that fumble or that errant pass, I need to intercept it. Not just intercept it or get that fumble, but run it back for a touchdown. Because the odds are stacked. Most of the time, I'm trying to hang on to the playing field, which is severely slanted just by my fingernails. So my approach is to make those prosecutors know that if they want my client, they're going to have to work harder than I am, and I will paper them to death. I will work them to death. I'll be nice. I'm not going to be a jerk until we get to the courtroom, but in the courtroom, I will do my darndest to cut their hearts out. And if possible, I'll take that knife and make those slow little incisions they don't even feel, so by the end of the case, when they turn their head quickly, their head will fall off. Doesn't happen very often.
Well, let's talk about that. You went out to El Paso maybe 10 years ago.
Yeah, back in 1993. 1993.
Hill?
Yeah, Gary Hill.
And he's a lawyer charged with bribery?
RICO with bribery and Hobbs Act as the underlying predicate offenses for allegedly bribing judges and or allowing himself to be extorted by the judges.
And you had, what, 45 counts?
No, actually the indictment wasn't bad. It was only, I want to say, 7 or 8 counts.
On the conspiracy charge, on the RICO charge, there were lots and lots of predicate offenses.
Oh, yes. Yes, definitely.
Tell me about, in your preparation for that case, how many individual case files did you go through?
After the judge granted the bill of particulars, so the government would at least tell us what cases, and then provided a list of 10 different acts of judicial discretion that were potentially related to each case. We had 256 files from the district attorney's office, the district clerk's office, and then Hill's files.
And how did you prepare for that trial?
I moved to El Paso. And Gary was in bed, I want to say May or June of '93. I moved there the next month, got a condominium. We got all of the discovery, which essentially was not just what I said, but also everything seized out of Hill's office, including the very nasty check stubs that had been written to cash and had the names of the judges on the check stubs, and proceeded to arrest.
Campaign contributions.
Didn't say campaign contributions, but be that as it may, there were no corresponding contributions on the judge's campaign report.
Problems.
That's not a good fact. Judge Donald Walter, who was assigned the case by Judge Husbeth, actually granted my motion to suppress in September of '93, kicking out the check stubs. As to Hill, they were still admissible as to the 2 co-defendants, Scott Siegel, who's now dead, and Judge Pena, who's no longer a judge. The government decided to do the interlocutory appeal as to Hill and put the trial of the other 2 on hold. So now I had sufficient time to truly get prepared. The Fifth Circuit, in a 2-1 opinion, reversed that motion to suppress, so I got to try the case a year later with the check stubs coming in against me.
94.
Actually, it was January of '95. We teed it up January 4th or 5th of '95, and in early February, the jury returned.
So in that case, you knew where every piece of paper was.
I did.
Knew what was the basis of every judicial decision.
I did. At least every judicial act of discretion in those files that was reasonably related to the dates on the 12 check stubs that had their names on it, and the word cash had been cashed, and obviously, allegedly, the cash had been paid to the judge.
So what was your explanation?
There was very little quid pro quo potential. The check stubs just didn't line up well. The government ultimately only put 5 of those cases into trial, into evidence at the trial. One of the dates, Hill had gotten a not guilty verdict by reason of insanity. That didn't make any sense to have paid the judge for anything. The other 3 or 4 were non-consequential, in my opinion. One disturbing because it was a 4-year continuance. So I investigated that myself, ascertained that the state court prosecutor had granted a continuance to Mr. Hill on this case because the discovery that Mr. Hill wanted would have revealed things about a federal wiretap that the federal government didn't want disclosed. In essence, that there was a dirty customs agent. And when I talked to the state prosecutor about that, I said, well, who was that federal prosecutor that told you not to give the discovery to Mr. Hill in this underlying state case? And that former state court prosecutor said, no one else but your current prosecutor of Mr. Hill in federal court. That was my rebuttal testimony. It was one of those rich moments in my career when the prosecutor literally crawled under the table, because the jury heard that the reason for that act of a continuance was directly attributable to the man that was trying to say that Hill had bribed the case for that same act of discretion.
So the act of discretion came not from the judge, but at the request of the federal prosecutor who was prosecuting.
Exactly.
And that federal prosecutor never disclosed that, did he?
No, he didn't.
And did the prosecutor in that case, state prosecutor, know that, testify that the federal prosecutor knew that Hill was the lawyer on that case?
Yes.
So, it sounds like suppressed Brady material.
Yes.
And I believe you probably argued that to the jury.
I didn't need to argue that it was suppressed Brady material so much as I argued that it showed the evil intent of the prosecutor in fabricating the case against Mr. Hill.
Evidence shaken.
No question.
And the jury looked at it and said,
The two-word verdict.
how many times?
Every time in the I think it was 7 times. Wasn't enough, but it was all they could do.
They were very upset with the prosecutor, wasn't
The prosecutor and the 2 agents sat in that courtroom for over 2 hours after the verdict, talking to themselves. They were somewhat distressed.
So your thorough investigation.
So get lucky, Stanley. But I think you make your own luck. I think you make your own luck by working hard.
Well, which leads me to, the discussion of the Hill case, leads me to 2 other cases that I know of yours. Mitchell and Richardson. Both of them seem to have carry on of that same theme.
Suppression of evidence?
Yes.
Just slightly, yes.
And both those men were death row inmates.
They were.
You have worked very hard over the last decade to educate lawyers, judges on Brady, the issue of Brady, suppressing evidence, and the injustice of the capital murder system in Texas.
Well, you're gracious, Stan. I try to do my part.
Well, let's talk about Gerald, is it Gerald Mitchell?
Andrew Lee.
Andrew Lee. Gerald Mitchell was my client, Andrew Lee Mitchell.
Andrew was tried and convicted in Smith County, 1981, represented by a former district attorney, court appointed. And when I got contacted by John Skelton, one of my death row clients who I was representing in connection with the direct appeal.
And he was acquitted.
He was acquitted on direct appeal by the Court of Criminal Appeals. It only took him 6.5 years.
But still, he was acquitted by the Court of Criminal Appeals.
Again, you get lucky from time to time. That was under the reasonable construct.
Right. 5-4 decision, I believe it was.
Actually, I think it was 6-3.
Okay.
6-3.
So
McCormick wrote that opinion, though.
All right.
Judge McCormick. But on Mitchell, Mitchell was a robust young man on death row that was protected. Black male. Although he looks a little bit more like an Italian. Mm-hmm. A little bit like Victor Mature, as a matter of fact. Very nice man. He was there on the row and was protecting Mr. Skelton, who was a semi-frail, elderly white man. And so John wrote me a letter saying, I want you to take a look into Andrew Mitchell's case. He's got an execution date coming up in like 30 days. Please do this. So I contacted the ACLU counsel that was currently handling the case before Judge Steger in federal court in Tyler. Mm-hmm. Got a copy of the record and read it, and I'll never forget this. The bottom of page, I think it was 63, I don't remember the page number. The end of the pretrial proceedings. Down at the bottom of the page, there's 3 lines. It says, whereupon the voir dire proceedings were had, but the same are not transcribed per order of the court. This is back in the days when a direct appeal from a sentence of death required, it was a mandatory appeal consisting of the entire record.
Right.
I brought that to the attention of ACLU attorneys. That was the theme at the stay hearing. Scrappy testified at that. Richard Anderson testified at that hearing on voir dire issues that were in that pre-existing federal writ. But that ultimate little squib down there is what ultimately caused Steger to abate the federal writ, allow me, who had since substituted in, to take it back to the CCA on a successor 1107. Court of Criminal Appeals ultimately ordered the voir dire to be transcribed. It was ultimately transcribed, and I then had a 2-week evidentiary hearing in Tyler on the entire ball of wax. I guess that was 1987 when he had the hearing. The stay hearing that I referred to earlier started in 1984.
So then you had, when did you find the suppressed Brady material? Suppressed evidence?
Found the suppressed evidence during the course of that time frame. I went back and read all the press articles. The deceased in this case had allegedly been killed.
Why did you read the press articles?
I wanted to learn about the case.
Why did you read the media?
Well, because, Stanley, I find that the media oftentimes says things that you're not going to see in a trial record.
Okay.
That oftentimes you can learn things about a case that you're not going to learn from a district attorney.
All right, so you read the press.
In Mitchell, the co-defendant testified that Mitchell killed the deceased at 8:30.
Okay.
The press articles reflected from the day after, quoted a friend of the deceased as saying that, well, he was alive and well with friends until 10:30. So there's an issue there, right to start with.
Right.
We ultimately contacted a witness that actually had driven by the scene of the murder. It was a fireworks stand,
Right.
at 12:30 the night before, the night of,
Right.
after Mitchell had allegedly killed the guy at 8:30, saying, I saw the deceased sitting there in the fireworks stand with the glow of the television on. He was found, the deceased was found laying down.
Right.
He was not dead in his chair.
Wasn't that in a report?
It ultimately did come out in a report that had been suppressed, depending upon who you believe, either by the sheriff's office or the DA's office. Don't care who at that time frame. And the writ judge on the 1107 wouldn't order inspection of the DA's file and the sheriff's file.
Mm-hmm.
Ultimately, he did it during the second week, actually at the end of the first week of the evidentiary hearing, and they ponied it up.
So a newspaper article
Led it to us.
led it to it, and Andrew Mitchell was given a new trial.
Yes. Court of Criminal Appeals granted a new trial due to suppression.
About 96.
Actually, I think that was 93 when he received the new trial from the CCA.
Okay. And he ended up pleading guilty for the time served.
In essence, that's pretty close. In 1999, he pleaded guilty to a conspiracy to commit robbery and was given a 31-year sentence, which was the equivalent of his flat and good time plus all calculations. So that's how it was worked out. But it wasn't technically for that time. And that occurred in the middle of jury selection. Scrappy Holmes and I were trying to get a jury on this case up in Quitman, Texas, where Cynthia Kent had moved the case. Of course, the alibi defense was that Andrew had been in a whorehouse with 2 girls doing drugs, which is enough to get you the death penalty in Quitman, Texas anyhow.
For a black man to be doing it.
Certainly. Or a white man, for that matter, in Quitman, Texas, probably.
Where's Quitman, Texas?
Just north, it's in Wood County, north of Tyler.
Okay, well, you just mentioned somebody a couple times.
Scrappy Holmes.
Scrappy Holmes.
Scrappy, I was introduced to Scrappy by Emmett. I can't remember the exact time frame. I've known Scrappy I've been practicing 31 years, almost 31 years. I've known Scrappy since I was a baby. And just like Frank, known from the baby. I've known you for, 25 plus years, whatever. Excellent former president of TCDLA, member of the Hall of Fame.
Well, there's more to Scrappy than that.
I understand, but I'm not going to talk for 2 hours here today.
Well, talk to me about Scrappy.
Scrappy is just probably one of the best lawyers in trial I've ever seen.
Tell me about that.
Scrappy tries more cases than anybody in the state. He can go in and cut a jury with no preparation, probably better than I'd ever be able to do. He's had such experience in the little counties around Texas. he's got such good instincts. So he'll tell you, if he leaves a fat woman on the jury, he's going to get the two-word verdict because they all love him. He's a big bear of a man. Big bear of a man. Booming voice, demands respect from everybody he sees and gets it from everybody he sees.
Loving man.
I'm sorry?
A loving man.
Oh, friendly, outgoing, give you his last dollar. Perfect gentleman, too.
As long as you spend the last dollar with him.
Well, that's true. And as long as it's spent on a little bit of tequila.
Or red wine.
He does have a hankering for red wine from time to time. And vodka, Grey Goose, I think is his favorite. And we drank a lot of that up in Texarkana a couple of years ago on a real nasty little case.
Well, tell me about that one.
That was a 130-plus count RICO indictment. I was representing the lead defendant. Scrappy was representing another defendant. We had a lot of meetings, or 8 or 10 attorneys in the case. Indictment was ultimately dismissed after the hearing on the motion to dismiss and the hearing on the motion to suppress. Judge Folsom essentially told the governor, you better dismiss this thing, or I'm going to grant that motion to dismiss. And if it comes back, I'll worry about Mr. Botsford's motion to suppress at that time. They did indict at this time. They came back with 140-something counts. But that ultimately was so. Everybody was dismissed out and given pretrial diversion except my client, who decided that in order to effectuate the deal, not only on his behalf but everybody else, he would agree to accept a 2-year guaranteed probation in federal court, paid them $2 million. They wanted 30. And so it was a business decision. Made a good choice. Probably would have cost him about $1.5 million to try the case.
For you?
Between my trial fees and the experts, yes, it would have cost him $1.5 million.
All right.
That's what we estimated, and that's how we made the decision. Hey, Doc, it's going to cost you an additional $500,000 to have them guaranteed. They're not going to mess with your other hospitals. And everything goes well.
Economics works.
It was a business decision.
So then we were going to talk about Richardson.
Well, David Richardson is a classic example of Lubbock abuse. I was appointed by the Court of Criminal Appeals in that case to do the 11071. In 1990, late 96, early 97, right about the effective date, or right after the effective date of the Anti-Terrorism and Effective Death Penalty Act.
Right.
And so, I'll say this about Lubbock. The then district attorney was not the district attorney in office at the time that Mr. Richardson was tried and convicted. Richardson, you'll remember, was the first tried of 4 co-defendants.
What happened to the other 3?
Well, let's see. The second one, that involves Stern versus Clinton. That's
Right.
where Chuck Lanehart and Carlton McClarty were disqualified by the judge. TCDLA Strike Force, of which I was a member, got them back on, saying the judge could not unappoint them. He was acquitted of a lesser-included offense of murder by Judge Gordon Gray. The third co-defendant was acquitted by a jury in about 2 hours. The fourth co-defendant, his case was dismissed. So Mr. Richardson was the only one of the 4 allegedly there doing things, causing the murder, that got convicted, and he was on death row. When I got appointed, I contacted the DA's office in Lubbock, asked to open records. I'd like to see your files. Bill Souter's office did. My investigator, Joe Ward, and I went up there and we went through box after box, and in the second box, I'll never forget it, a manila envelope. Open it, not labeled, open the manila envelope. Inside is a diary, a handwritten diary by a police officer, describing her day-by-day experiences as she was guarding the state snitch. During the course of a year, the state snitch was in protective custody before Mr. Richardson's trial. It reflected the names of the other officers that had also been on that protective detail. So obviously I contacted her, contacted the other police officers, and developed the testimony at a writ hearing that lasted 3 weeks. Testimony to the effect that if those officers had been disclosed and been subpoenaed at trial, they each and every one would have testified that that snitch was not capable of belief under oath. She was a no-good lying bitch, pardon my language. But what was even better What was even better is in this envelope was a memo from the then Assistant Chief of Police to Travis Ware, the then elected district attorney of Lubbock County, enclosing a copy of the diary. And so, here it is in the DA's file. Here there is a memo attached to it, the copy, to Travis Ware. The DA's office took a position, they never knew about it, never heard about it, don't have any knowledge how it could have gotten in the file. I thought they were going to say I planted it, quite candidly, but that didn't happen.
Eventually, 4 or 5 years later, Court of Criminal Appeals writes an opinion of Richardson saying, suppress Brady material, we need to retry.
Case should have been retried. We did retry. We pled him for time served on a lesser included offense. He was already serving a life sentence on an organized crime case. That was Damon's decision with input from us. I think it was a bad decision by me. In hindsight, I just should have tried it. Of course, if he had gotten convicted, I didn't think he could be convicted. Because I told him, I can't guarantee you a jury's going to walk him. Yeah, I think the snitch who is now so far discredited as not to be believable, but you know, I can't tell you what a jury's going to do. I can tell you one thing though, given your record, including the organized crime case, which was based on his drug dealing from the jail during the pendency of his capital murder case, I think the odds are pretty good that a West Texas jury is going to give you the needle. Mm-hmm. And then it'll take another 6 or 8 years to probably get it reversed, if it's capable of being reversed. So the deal was cut, time served with the state writing a very nice letter to the parole board saying, not only do we agree not to protest parole, we think he's a candidate for parole. That's the bottom line. It was a very glowing report.
Is he out of jail?
Gary Cohen is currently working on that parole on the organized crime case.
Now, you worked, we've talked about some of your cases. It'll last nearly an hour.
Sorry about that.
And there's a theme that comes from it. A theme of dedication, hard work, and a scholarly approach to law. Is that the way you approach it?
That's what I was taught by Emmett, Frank, Truman.
Scrappy.
And scrappy, every lawyer I've been around that knows what they're doing consistently had those traits. I'm not sure I ever had those on my own, Stanley. I think I was very lucky to be in the right place at the right time, getting to work for Emmett, and then Truman, and then Frank, and the association of lawyers around the state. I'm very, very fortunate.
You've been an outspoken critic of fraudulent forensic science, as you saw in Richardson's case with Erdman.
Mm-hmm.
Tell us about that.
Forensic pathology, fraudulent forensic practice is epidemic in this country.
Well, that was a topic that we almost got lynched on.
Well, that's true. We were in Reno and advocating that at the 52nd Annual Forensic Academy of Sciences. But it's true. Erdman, classic example.
Who's
Fred
Erdman?
Zane. Erdman was a pathologist in the Panhandle, North Texas, Lubbock, Amarillo, that just was a hack. He would testify to whatever the district attorney's office wanted him to testify to. No telling how many people he falsely got convicted. He ultimately was convicted for offenses relating to some of those, served some time. I think actually Phil Wishcamper represented him. But terrible, terrible misdeeds, like your Fred Zane case in San Antonio, actually, I guess it's in Braunfels. So many people compromise the truth under the theory that the ends justify the means. And the ends can never justify the means. What we're doing in Guantanamo today is a revision back to the days of coerced confessions, which the Supreme Court said back in 1936. You can't allow that. You can't allow somebody to be hung by the neck and pulled up on that tree limb, put back down, hung back up, whipped until you confess. That's not right. And this society's forgotten it. This president has condoned it. I'm offended by my president. I'm offended by my government. How dare they do to this American people what our Supreme Court said 40 years ago was unconstitutional? Damn them. I'm sorry. I get a little emotional from time to time. I once apologized. I once told the jury in final argument to Clinton Angus, on behalf of my country, I apologize for my government because they were so outrageous. You know, it's not right. The ends do not justify the means. Can't. The second we let that occur, this has not become a civilized society. Of course, just this last Wednesday, we had an affirmation that it's still going to be a civilized society in this country. We're not going to allow the ultimate penalty to be imposed upon child rapists, despite the hue and cry of the religious right, and despite the fact that nobody condones that. Certainly nobody condones that, but the ultimate penalty, absolutely not. Of the 180 people that were exonerated based on DNA evidence up through June of 2006, 44 of them had given false confessions. Not physical abuse that coerced that confession, but psychological abuse. Just as bad, maybe worse because it's more subtle. You can stay in pain, but physical pain is different than mental pain. And mental pain is something that nobody should have to suffer. Sorry for me getting on my bandwagon, you understand?
Well, David, we're almost finished with this, but I think that the passion you just showed typifies you as a person and typifies you as a lawyer. I know one of the saddest moments in your career was when Carla Faye Tucker was executed. You and Mac were representing her. And how did that affect you? How did her death affect you?
Still affects me, Stan. I didn't know you were going to ask me about that.
I just thought of it. I thought of it as you were talking about the injustice of the government and talked about the injustice of it. Just came to me as you were talking about the Kennedy decision, and I knew I've known the pain that is in it, but to me, I think that your pain represents what many of us feel.
Anybody that knew Carla at the end committed a terrible crime. Drug craze, terrible crime, needed to be incarcerated. But the Carla Faye Tucker that our current president, then Governor Bush, allowed the state to kill didn't need to be killed. She was not a future danger. She was doing good things in the penitentiary. She was truly had undergone a religious conversion. You could see it when you spoke with the glow about her. She was perfectly content to die. She was prepared. She was at peace with God, her God. And there was no real good reason to kill her other than the fact that our governor wanted to become president. And that's why he did it. Because he told somebody the week before she was executed he was not going to pardon her, actually, commute her sentence. Despite the fact we agreed to life without parole, because you can't get elected president helping a pickaxe murderer. So it's affected me psychologically, Stanley.
Are you more committed to fight capital punishment?
Certainly on one level I am. On another level I'm probably not, Stanley. The psychological impact of death cases takes a tremendous toll. You've handled far more than I have. You know what I'm referring to. It also took a tremendous toll on me through my life in terms of taking time away from my family. And essentially, I don't think that, at least for the next couple of years, I'm going to be doing as much of that. I think I've got about 20 good years left.
Well, you're 52?
I'm 55.
Really?
I'm 55. I'm hopeful I got another 20 good years. And certainly I want to keep my hand in the capital arena. but I just am personally not prepared to spend as much time there as I have before. I want to try to share and pass on what I've been so fortunate to have been blessed with, the experiences and the lessons that Emmett and Frank and all these other folks have taught me. I want to pass that on to other people. That's one reason why I agreed to do this. But I mean in the local community, not just with young lawyers that need to get the passion and realize this job is not about money. This is about dedication and truly being there to protect the citizen accused from an overzealous government. That's the message that the young folks coming out of law school need to get. This is not about the pursuit of money. You don't get rich practicing criminal law. But my God, you can make a difference to this society. And if I can make one little benefit to society doing something that I love to do, then I'm the luckiest person in the world.
Well, David, thank you very much.
Thank you.
And I am the luckiest people in the world to have you as a friend.
Well, Stanley, you and I go way back, and you're one of my nearest and dearest friends, and I appreciate you doing this.
Thank you, David.
Thank you, Stan.